Welcome to the lesson on Rome II regulation and the UK Post Brexit regime on torts and non-contractual obligations. As usual, the learning materials for this topic can be found in the description below the video in order of appearance. During the United Kingdom's membership of the European Union, the law governing torts and related non-contractual obligations evolved through two distinct instruments: the Private International Law, Miscellaneous Provisions Act 1995, PIL, and the Rome II Regulation, 2007. The former applied to torts committed on or after 1st of May 1996 and broadly before 12th of January 2009, while Rome II has governed events giving rise to damage that occurred after 11th of January 2009. Whereas Rome I focused on contractual obligations, Rome II dealt exclusively with non-contractual ones. Both instruments have drawn extensive criticism, although for different reasons. The PIL 1995 represented a radical departure from the common law rules of choice of law in tort. It abolished the earlier flexible, judge-made doctrines and replaced them with statutory rules that many commentators, including Morse and Carter, regarded as clumsy and uncertain. Rome II, in contrast, was criticized mainly for political compromises that shaped its design. Its central rule, contained in Article 4:1, provides that the applicable law is that of the country in which the damage occurs, regardless of where the harmful event took place or where its indirect consequences are felt. This approach, a variant of the lex loci damni principle, was thought to extend the rule in Beer versus Mines de Potas into choice of law, while preserving the logic of Dumes and Marinari. Yet Trevor C. Hartley has attacked this approach for being ineffective and unworkable by creating difficulties in determining jurisdiction and reducing certainty. By comparison, Section 11 of the PIL 1995 identifies the applicable law as the law of the country in which the events constituting the tort occur. If those events span more than one country, the Act defaults to the place of the tort, with an exception under Section 11(2)(c), which allows courts to apply the law of the country where the most significant elements occurred. Critics found this significant elements test to be vague and destabilizing, thereby undermining legal certainty. On this view, the cleaner approach of Rome II appeared preferable, even though it too was imperfect. Rome II also contains a number of important exceptions. Article 14, freedom of choice, allows parties, particularly commercial actors, to select the applicable law after a tort has arisen, or even in advance, echoing traditional English principles of party autonomy. Cadna Graziano argues that while rarely invoked in practice, this escape clause has been controversial because it arguably empowers stronger parties to dictate the governing law. A further exception appears in Article 4(3), which allows displacement of the general rule where another country has a manifestly closer connection with the dispute. Finally, the regulation also recognizes a public policy exception. Supporters of these exceptions argue that they inject flexibility and enable harmonization across member states. Critics, however, including Simeonides, charge that the profusion of escape routes undermines certainty and represents a missed opportunity to build on the sophistication of modern European conflicts law. Kate Vernon and Cordelia Rayner note that the issue of certainty resurfaced after Brexit. Under the European Union Withdrawal Act 2018, both Rome I and Rome II were retained in domestic law, meaning that UK courts continued to apply them after the end of the transition period as though the UK was still a member state. This intention was operationalized through Regulations 2019-83, which ensured that Rome I and II would continue to apply even though the UK had become a third country. However, the long-term status of Rome II has been destabilized by more recent developments. The retained EU Law Revocation and Reform Act 2023 sought to reassert parliamentary sovereignty by ending the supremacy of EU law. Although initial proposals for a sweeping sunset clause were abandoned, the final act allows retained EU law to be revoked or amended more easily. Rome I and II were not expressly revoked in the 2023 schedule, so technically they remain part of UK law. Yet the removal of EU law supremacy means that if conflicts arise between older UK legislation such as the PIL 1995 and Rome II, the domestic statute may prevail. This effectively reopens the possibility of inconsistency between the two regimes and forces UK courts to reconcile them in practice. This new legal landscape raises the prospect of renewed uncertainty. Rome II itself has been criticized by Lawrence Collins for leaving important questions unresolved, such as its applicability to torts committed on the high seas or in outer space. Nonetheless, many scholars argue that Rome II, despite its flaws, is more coherent and predictable than PIL 1995. Because, as Adrian Briggs remarks, Rome II offers perfectly serviceable rules of private international law, it can be regarded as a self-contained regime even outside the EU framework. In sum, the UK's law of tort has been shaped by two competing frameworks regarding choice of law. The PIL 1995 introduced statutory clarity, but did so through awkward provisions that bred uncertainty. Rome II promised uniformity across the EU, but adopted politically motivated rules that created their own difficulties. After Brexit, both regulations were preserved in domestic law, yet the UK's subsequent retreat from EU legal supremacy now casts doubt on their continuing authority. Going forward, UK courts will likely face challenges in reconciling Rome II with earlier domestic law, particularly the PIL 1995, while continuing to grapple with Rome II's inherent ambiguities. Still, Rome II may remain the preferable regime because it provides reasonably consistent, serviceable rules and reflects the UK's long-standing engagement with European private international law. Thank you for your interest in this topic, and we are looking forward to seeing you again soon.